there are two additional responsibilities I'm going to talk to you about. The first is the board may be called upon to serve as a quasi-judicial board to resolve disputes. School board members are asked to take on this function in cases that require a person to receive due process. Examples that may require such due process are the renewal or non-renewal of teacher contracts, dismissal of a principal, or student suspension and expulsion hearings. There are statutory requirements governing the timing and process for bringing these types of appeals before the board, and I'm not going to get into those right now. What I am going to emphasize is that at all times board members must maintain their impartiality in order to ensure the process has integrity and credibility. This means that board members should not get involved in matters such as the ones I talked about above that could come before the board in a judicial capacity, because any prior involvement you run the risk of creating an unacceptable bias in favor of one party versus the other. The last thing I'll mention is that these deliberations, the deliberations of a board in serving the quasi-judicial function are exempt from Vermont's open meeting law. The second additional responsibility is a critical role for board members and also a challenging one. I'm sure many of you have heard of situations across the state that are where your colleagues are in a difficult place at the table. So it's important that you understand a dynamic that's at play here. Negotiations under state law are conducted by a negotiations council at the supervisory union level, and that council has representatives from all member districts. However, final ratification of any agreement on behalf of a school board is the sole responsibility of that board. So the decision to ratify or not ratify remains at the board, but negotiations typically happen at the supervisory union level. We could do an entire webinar on negotiations, and we plan to do so later this year. But that's the piece of information I want to leave with you tonight. So the next piece are some guidelines for effective and ethical operations of the board. The first thing is you should know is that individual board members have no legal powers outside the board. That means that board members don't have a special status or legal authority as individuals. If you're a parent and you have students in the school system, you should not get special treatment for your children. You don't have the authority to direct staff to do things that you'd like them to do. The best approach is to bring any issues that you're aware of to the board and resolve them there at the board level, not as an individual. The second is boards should follow Vermont's open meeting law. I'm going to do a brief summary of our open meeting law. We have a lot more information in our resource guide that both Harry and Steve referenced earlier. Under our open meeting law, all meetings of a public body, including subcommittee meetings, are open to the public at all times. No formal action is valid unless it's been taken in an open meeting. The public must be given notice and a reasonable opportunity to be heard. And the amount and type of notice depends on the type of meeting held. And again, those specifics are included in our essential work guide. A couple thoughts on executive session. Executive session is essentially a closed meeting within an open meeting. A board member must make a motion that states the nature of the business to be discussed in executive session, and there are only a limited number of allowable subjects that can be discussed in executive session, and those are all spelled out very clearly in statute. If the board does vote to enter executive session, they can only discuss the subject matter referenced in the motion. And then if a decision, any decision or votes need to be made out in public, back in the open meeting. So the board only deliberates in executive session. The third point is, both Steve and Harry have mentioned it, and I will again, because it is one of the primary messages we hope to convey tonight. Board members assure that schools are well run, but don't run them. Board members have to avoid the conflict of interest or the perception of conflict of interest. The integrity and credibility of the board depends on public trust. And the public needs to trust that board members are making decisions that are in the best interest of students and taxpayers, not in their own self-interest. So if you have any question in your mind about the existence of a conflict, and we're going to, hopefully with time allowing, get to a case study that'll explore this issue a little bit deeper. But it's best for that board member to refrain from both discussion and voting on the topic entirely. And the last point on this section is to recognize the validity of board decisions, even if you don't agree with them. Certainly board members can disagree with the outcome of a vote, but we would ask or encourage board members to respect the functioning of the board, the process that the board went through to reach a decision, and ultimately the fact that it is the final decision of the board.